Welcome to another ARPOLA on-the-go educational session. Today we're going to talk about the basics of a lease. Now, some people call their documents a rental lease, some people call them rental agreements. To be very strict in interpretation, a lease is something that has a fixed term. Generally, a one-year commitment is a lease. A month-to-month agreement is truly an agreement. But both of them have the components of a contract, and brings us to contract law. A contract is an agreement that the law recognizes as being legally binding on the signature parties. So you have responsibilities within the lease that are outlined, and your resident also has responsibilities within that lease, and those have to be enforced. Now, there are certain elements of a lease agreement. This is where contract law meets property law. And a lease is a contract whereby the owner of a property permits another person, or the resident, to use that property for a period of time in return for rental payment. As you prepare your lease, you need to think about your rental policies. Make sure that your policies actually show up correctly in your lease documents. So have consistency throughout. As you're also drafting the lease, make sure that you keep in mind to not put yourself at risk for liabilities. So check with your attorney, or if you use the ARPOLA forms that are state specific, those will help limit the liabilities. And another way you do that is by being reasonable, rational, and not unlawfully discriminatory. One of the biggest liabilities that people that draft their own leases bring onto themselves is discrimination. They don't mean to. They certainly would not have intended to do that, but because of the way they write the language of the lease, it often turns out to be that way. And taking care that you don't make fraudulent misrepresentations about the property, about your service, or about anything that turns up in the agreement. Now, there are four basic elements of the contract, any contract. There's the offer, the acceptance, consideration, and capacity. And once these four requirements have been satisfied, a contract will generally be deemed to be enforceable. In a lease agreement, offer is made when the application is complete and the parties to the lease reach agreement on the major terms of the lease. There is consideration because money changes hands, and the parties are competent and have the ability and capacity to contract. So you know that as you walk through your process, you actually have a legally binding contractual agreement. Some of the major terms of the lease obviously has to be the address of the apartment to be leased. So when you sign that lease, it does have to appear, either the address or the unit number has to specifically appear in there. If it is a multi-unit complex, then you will also need the apartment number specifically, not just the address of the actual community. The amount of rent needs to be present, how often the rent is to be paid, and the term of the lease. Is it month to month? Is it 1 year? So how long does the person have inside this contract? Now, as you're thinking about the lease duration, one thing that you may want to think about is how the property is positioned. Abilities are a fixed term lease, a month-to-month lease, or a lease at will. I would not suggest a lease at will, but there are definite pros and cons between the fixed term lease and the month-to-month lease. A lot of owners choose a fixed term because they believe that it will keep someone in the lease who may want to leave. I would suggest not only is that not true, keeping someone within a lease that they don't want to be in can often have results that you didn't expect. It can build frustration and anger on the part of the resident, which can lead to property destruction. It can cause an eviction and the cost of an eviction. So a fixed term lease may not always be your best option. A lot of owners also choose a fixed term lease because they believe that they can get a judgment against the resident if the resident leaves before the lease term is up. In the many, many years that I have been in the business, I have not had very much success at all in collecting those judgments. Generally, the reason someone wants to leave has a lot to do with the rent amount or other possible issues that would keep me from also being able to collect the judgment. So a month-to-month lease may work just as well for you. The other thing about a month-to-month lease is if you have a problem property in a problem area and you are trying to really monitor the upkeep of that property and you're trying to make sure that you are keeping the best residents at all times in the property, but yet the property has a bad reputation and sometimes you're having a challenge with getting the right resident, a month-to-month lease will allow you to say owner wants possession and be able to give a 30-day notice or whatever the notice is in your state and move on. So you may want to keep that in mind. You also need to be clear about what the lease termination would look like. So at the end of the lease, what happens? If it's a 1-year lease, does it then go month to month? Does it automatically activate another year? What does that look like? And that needs to be covered in the lease.